First of all, let me tell you, sitting in the last panel as a co-panelist, after hearing all these speakers, is as bad as convincing a lawyer to mediate. So, anyways, you see, arbitration, mediation, conciliation is not a new concept, but somehow it's not driven the way it should have. And it has some reasons behind, and I'll take just 2 minutes to let you know what are the impediments, why this is so difficult for us to flourish this system of okay, mediation, arbitration, reconciliation. See, this part of land was once a subcontinent, and it was the richest land on this globe. Richest in the sense that trade and all over traders around the world were eyeing this land as to trade with those who are trading from this part of the land. Then in the 16th and 17th century, if I remember, this part was invaded, and the invasion was from East India Company. Before that, the trade was being done without any dispute, without any fear. The disputes, I'm sure, must have been there, but were being resolved. The new name that we are giving to the present system is through arbitration, mediation, and during those days it was through panchayats, through elders. But somehow a system was introduced, and that is adversarial system of litigation to dispense justice. That to me is a root cause to deviate ourselves from our traditional way of dispensing justice, that is mediation, arbitration, conciliation, and then arbitration if at all required. So, to me, the main issue is the legal frame. Unless we provide a model through a principal law, and that is, to me, that is a constitution, unless we provide a model to promote this culture of resolution of a dispute through mediation, conciliation, negotiation, this would not be a successful attempt. Again, now, the biggest problem in promoting this culture, this is a culture, by the way. The biggest impediment, I would say, I won't say impediment, but the biggest issue is to convince a lawyer. Because unless we convince a lawyer that this is a better alternate, our success percentage would be almost negligent. Now, a lawyer would never want a dispute to be resolved. A lawyer wants litigation, whereas a litigant wants the end of dispute. Unless a lawyer is honest in his opinion that these are the good lines in your case, and these are the negative aspects in your case, and a litigant is made to realize that a litigation is not an absolute way out. He may not be successful at the end of the day. Unless a litigant is honestly told about it, this system will not work. Now, I'm sure we can't develop this culture in months or in years. This would take some time. Now, only thing is that we need to train not only the lawyers, but the judges as well, that their professionalism will not going to come to an end by the introduction of this culture of resolution of a dispute through mediation and negotiation. Throughout the world, like East India Company introduced this system, and in their own country, they have promoted arbitration throughout. They never it's very seldom that the litigant would go to the court. Whereas in this part of the world, this system has flourished. It has deeply rooted now. So my concern is that unless we train, we groom our own lawyers to give an honest opinion, we should let them know that their professionalism is not going to end here. They would get a settlement fee which would be far more than what he would get to file a case. Throughout the world, this practice is going on, and this require awareness. I'm sure if we organize these kind of seminars or conferences, this would make it common to the not only to the litigant but also to the lawyers that this is a better way out. Now, why I would say for the litigant that this is a better way out? This is a commercial hub. A litigant not only want the end of litigation or end of dispute, this alternate dispute resolution would give you one thing in bargain, and that is to me that is more important. And that is the relationship with your counterpart. You don't have to have a battle with your counterpart. You can negotiate, get your piece of cake, yet maintain the relationship. So to me, not only the law reforms, but the training of the lawyers, judges is inevitable. And unless we come across this, we need to make some more efforts to flourish it. Sir, you said, Abraham Lincoln has said that a good alternate dispute resolution bargain is better than a case filed. Let me tell you that we are here to guard our jurisdiction as well. So don't count on that. I just forgot to tell, do I have time, sir? 2 minutes. Yes. So in my earlier statement, it's not that I am not advocating for an alternate dispute resolution centers. But I would first advocate to have court-attached mediation, or those mediators should be attached with the court to give a kind of a confidence to the litigant that this mediation is part of the litigation that they have initiated. This is one. Two, if you provide that many centers, alternate dispute centers, and we don't provide them enough cases to resolve, then वो कहते हैं ना कि a box office failure on the first day, that might not happen. So there should not be that many alternate dispute centers. Let them be burdened. Let the people realize that perhaps it is a right way to have a solution of their disputes, and only then gradually we can provide these dispute centers. But in the first instance, my vote would be for attached kind of mediators with every courtroom. Like every courtroom should have at least 10 mediators. The court can refer those matters to those mediators. The litigant have a confidence that he is within that court, and then the mediator will respond to it if it is successful or otherwise. Thank you, sir.